Yeah. All right, Mr. Baker, you're before the court day for your arraignment. And let's see. You're not. Have you hired an attorney?
No, sir.
Do you plan on hiring one?
No, sir.
Are you going to represent yourself, or do you wish to have a public defender to represent you?
Today, we're traveling to Florida, where a self-declared private citizen chooses to represent himself in a felony arraignment hearing. As soon as he enters the room, it's obvious that the judge is impatient with gain.
He's been charged by way of an information with possession of a cocaine, possession of a controlled substance, count 1 and 2. Those are both third-degree felonies, punishable to 5 years in Florida Department of Corrections and a $5,000 fine. You have a count 3, which is fleeing or attempting to elude high-speed reckless. I believe that should be a second-degree felony, punishable to 15 years in the Florida Department of Corrections and a $10,000 fine. Count 4 is driving while license, cancel, suspend, or revoke third or subsequent offense. That's a third-degree felony, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. And count 5, possession of marijuana less than 20 grams, which is a first-degree misdemeanor, punishable to 1 year in the county jail and a $1,000 fine. So you're looking at a total of about 30 years in the Florida Department of Corrections if you're convicted of everything and you get the maximum sentence. And you're still wishing to represent?
The judge begins listing the charges, which are all more serious than the last one. Cocaine, controlled substances, high-speed driving, suspended license, and marijuana possession. But the defendant calmly insists on representing himself. The judge even threatens to sentence him to 30 years in prison and offers him a public defender, but he refuses. This isn't confidence. Rather, it's a total misinterpretation of how the legal system operates. Sovereign citizens enjoy pretending that legalese is optional, but in a courtroom, miscommunication is inevitable. The judge tries to explain the issues, but our Florida man refuses to back down. Let's simply say that today's courtroom lacks rationality.
Sir.
Mr. Baker, state your name.
Lee Baker.
And Mr. Baker, you have asked to represent yourself. Is that correct?
Yes.
How far did you get in school?
9th grade.
Okay. And so you can read and write?
Yes.
Okay. Are you employed?
No, sir.
All right. How do you make a living?
I'm unemployed right now. I was living with someone else.
Sir?
I'm unemployed. I was living with someone else. I just got out of jail about 5 months ago.
Okay. Well, what is your trade?
I have my own business.
All right. What kind of business?
A cleaning business.
Okay. And have you ever represented yourself before?
Yes.
All right. Let's see. Are you under the influence of any drugs or alcohol today, which would affect your ability to make this decision to represent yourself?
No.
Have you ever been diagnosed with a mental illness that would affect your ability to to make this decision?
The judge proceeds to inquire about prior legal experience, schooling, and job. The judge emphasizes that legal training matters, especially in criminal court, and that the system won't bend for him just because he's confused, but our defendant is set on playing lawyer. He nods along, claiming to understand everything. However, comprehension and legal competence are two very different things, and we're about to see that gap widen by
Pretrial motions, preparing for pretrial hearings, and to participate in discovery, and also preparing for trial.
I comprehend that very well.
All right, and sir, you understand that if you're representing yourself, you'll be held to that same standard.
I comprehend that.
All right, and I cannot assist you in any way. The state attorney would not be able to assist you in any way. Is that correct?
I comprehend.
All right, and you still wish to represent yourself?
Yes.
All right, Madam Clerk, if you'll print out the information, and Deputy Dexter, it's okay if the clerk hands the information to Mr. Baker? All right, Madam Clerk, if you'll do that. Mr. Baker, when you receive that information, I'm going to ask that you enter a plea at this time.
I'd like to file some motions on the record as well, sir.
I want to do your arraignment first.
All right.
All right, whenever you're ready, you'll let me know and you enter your plea.
I end up pleading not guilty.
Okay. All right, you're filing motions?
Yes, sir.
Now it's time for the plea. The defendant enters a not guilty plea, then immediately announces he's ready to file motions. But the judge reminds him to start with the basics, like sharing copies with the prosecution. Instead, the defendant hands over something he calls a decree of judgment, treating it like a magical get-out-of-jail-free card. He claims it's a bond that entitles him to be released without going through the actual bail process. This is classic sovereign citizen behavior, using obscure, printed documents in an attempt to override real law. The judge stays firm, explaining that's not how the legal system works. But the defendant sticks to his script, no matter how far off base it is. He keeps pushing his paperwork, insisting it obligates the court to release him. He tosses around unfamiliar legal terms and misquotes federal codes like they're cheat codes. The judge has clearly had enough. He strikes the nonsense from the record and delivers a firm warning. Bring this up again, and you'll lose the right to represent yourself. That's not just a threat, it's a reality check. When defendants waste court time with irrelevant or fraudulent legal arguments, the court has every right to intervene. Fake legal tactics won't make serious criminal charges disappear, and this judge isn't about to indulge in fantasy law.
I want to furnish this bond to the clerk
You file it. Go ahead.
for my release from the Bay County Jail today.
Okay.
That's the judgment. That's for the clerk only.
Now you providing a copy of the state, everything you give the clerk.
The bond, I shouldn't have to give the bond. The bond goes straight to the clerk.
Anything you file that you want me to consider, you have to provide a copy to the state, sir. As you're representing yourself, you have to know those rules. If you don't, you're going to mess up.
I understand that.
If you're not providing to the state, I'm not going to consider it.
Okay.
And the clerk doesn't make any determinations on that. All the clerk determines is whether you're innocent or not.
I'm not talking about the bond for the debtor judgment.
The courtroom becomes tense as the judge schedules a future hearing. But when he warns the defendant about continuing this behavior, the man interrupts once more and insists that he is only a private citizen and not a sovereign citizen. The judge isn't playing word games, whether you call it private national or anything else. If you're acting like a sovereign citizen by using fictitious legal arguments and disobeying court protocol. The defendant continues to argue that his titles don't matter what he does, and the judge cuts him off. You can almost feel the courtroom holding its breath.
Talking about eligible obligation on the USDA.
Oh, you talking all that kind of stuff. I'm striking all that. And if I hear it again, I'm not going to let you represent yourself. I promise you. He's already entered a not guilty plea. We'll set this for pre-trial. We'll set it for don't ask me any questions like that, sir. I'm not answering any questions. If you want to file a motion, file your motion. We'll set it for our December. When's that motion day in December? December 19th at 9:00. Sir, you may, if you're going to do the sovereign citizen, all that, you may want to consider having the attorney.
I'm a private citizen. So
When the defendant wouldn't stop talking, the judge repeatedly ordered him to stop, but he persisted. The judge then said, "One more word, and it's over." And with that, the defendant was physically removed from the courtroom.
Yourself?
no, sir.
But I'm not going to pay attention to any of that. And I'm going to strike all that.
Okay.
So we'll see you December 19th at 9:00.
It's no problem. Oh,
That's enough. I don't want to hear another word.
okay. I'd like to also.
I don't want to hear another word. No, put him out.
Put your hand on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush. Whoa. Mr. Baker, I'm going to appoint the Office of Public Defender to represent you. I'm going to find that you're not competent to represent yourself at this time. I'm going to reverse my decision. The Office of Public Defender is going to represent him. We'll keep it on that December 19th date.
I'm officially represented by an attorney, and the defendant is no longer in charge of his case, which may be the best course of action because, regardless of whether he believes he is a sovereign citizen or not, his actions have demonstrated that he is not. Filing pointless paperwork, misinterpreting the law, and disobeying orders won't get you anywhere in court. The judge makes it clear that this isn't a place for ideological tirades or made-up rules. Rather, it's about facts, law, and accountability. So even though the defendant may think he has everything worked out, the court has made it very clear who is in charge.
Now, they'll close that door where I can't hear him.
As the session wraps up, the judge offers a few final words. He reminds everyone, especially the defendant, that only the court holds jurisdiction and courtroom decorum isn't optional. It's a subtle but firm message. No matter what title you give yourself, if you're standing in a courtroom, you play by its rules. The defendant is now officially on the path to trial. But the bigger question remains, will he keep resisting his court-appointed attorney? If he does, he might land himself in even more legal trouble before the actual case even begins. For now, court is adjourned. So, what can we take away from this? Trying to represent yourself using sovereign citizen logic is a recipe for disaster. Courts operate on legal facts, not internet theories. The judge gave the defendant every opportunity, clear instructions, patient explanations, and the chance to enter a proper plea. But once the legal process was derailed by fantasy documents and outright defiance, the court had no choice. He lost the right to represent himself, was removed from the courtroom, and will now face his charges with a court-appointed attorney. This case is far from over, and if past behavior is any clue, the next hearing might bring more courtroom drama. Be sure to like, comment, and subscribe. We'll be here to break it all down.